Get ready for the dictation. Start. The suit, as per the pleadings, is that of eviction and messany profits on the averment that the plaintiff respondent is the owner of the property. He has claimed ownership on the strength of the aforesaid documents, especially the agreement to sell and the memo of possession, as well as the receipt of payment of sale consideration. No doubt, agreement to sell is not a document of title or a deed of transfer of property by sale, and as such may not confer absolute title upon the plaintiff respondent over the suit property in view of section 54 of the Transfer of Property Act 1882. Nonetheless, the agreement to sell, the payment of entire sale consideration as mentioned in the agreement itself and corroborated by the receipt of its payment, and the fact that the plaintiff respondent was put in possession of the suit property in accordance with law, as is also established by the possession memo on record, goes to prove that the plaintiff respondent is de facto having possessory rights over the suit property in part performance of the agreement to sell. This possessory right of the plaintiff respondent is not liable to be disturbed by the transferor, that is the defendant appellant. The entry of the defendant appellant over part of the suit property subsequently is simply as a licensee of the plaintiff respondent. He does not continue to occupy it in capacity of the owner. In the wake of the finding that the above mentioned documents have not been fraudulently obtained or have not been manipulated, treating the said documents to be duly executed and as genuine, one thing is clear, that the plaintiff respondent is in a settled possession of the suit property, at least in part performance of the agreement, which cannot be distributed or disputed by the transferor, that is the defendant appellant. At the cost of repetition, the suit is for eviction of the defendant appellant from the suit premises and for recovery of messany profits on the ground that after the defendant appellant has parted with the possession of the property in favor of the plaintiff respondent in part performance of the agreement, he has no right to disturb his possession. He is simply a licensee, and the license having been terminated, he has no right to remain in possession but to restore possession to the person having rightful possessory title over it. It goes without saying that the power of attorney executed by the defendant appellant is of no consequence, as on the strength of said power of attorney neither sale deed has been executed nor any action pursuant thereof has been taken by the power of attorney holder which may confer title upon the plaintiff respondent. Non-execution of any document by the general power of attorney holder consequent to it renders the said general power of attorney useless. Similarly, the will dated 10/4/2002 executed by the defendant appellant in favor of the plaintiff respondent is meaningless, as the will, if any, comes into effect only after the death of the executant and not before it. It has no force till the testator or the person making it dies. The said stage has not arrived in the present case, and therefore even the aforesaid will in no way confers any right upon the plaintiff respondent. In connection with the general power of attorney and the will so executed, the practice, if any, prevalent in any state or the High Court, recognizing these documents to be documents of title or documents conferring right in any immovable property, is in violation of the statutory law. Any such practice or tradition prevalent would not override the specific provisions of law which require execution of the document. Stop.